Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back to the Aitken Robertson YouTube channel. And today I'm joined again by counsel Phil Stiles to answer some important questions with regards to the Ghomeshi case. Phil, for those who are unfamiliar with it, can you briefly give us an idea of the Ghomeshi case and its significance in Canadian law?
The Ghomeshi case was a high-profile decision that was, it was a case that was decided in 2016, and it involved a CBC radio host. Ended up being a very high-profile and contentious matter that garnered a lot of public attention. Essentially, it sparked a whole slew of changes to the criminal code in terms of the way evidentiary matters are dealt with in sexual assault cases, resulted in many amendments and additions in the criminal code. The main impact, you could spend an afternoon talking about all the ways it changed things, but the main impact that it had on sexual assault case law is that it completely revolutionized the way the courts deal with private records. And the main reason for that was the defense in the Ghomeshi case had all kinds of emails and written text communication that was somewhat private in nature between Mr. Ghomeshi and all of the complainants, kept them in their back pocket, essentially got into trial, and then after the evidence was impeachable, presented them. They were contrary to the evidence of many of the complainants. It essentially discredited them. The flip side is this created an uproar. Various victims groups and people who tend to support complainants, and it resulted in big changes to the criminal code. And so now the defense is required to bring a special application if they want to adduce into evidence any record where there's there would be a reasonable expectation of privacy, which we can talk a bit about what defines reasonable expectation of privacy. But private records are now litigated up front, and the defense has to show why they're relevant.
How has the reasonable expectation of privacy regime changed the way complainants are prepared for trial?
Well, now complainants are entitled to retain their own lawyer. Essentially will advocate for them during a two-stage private records application that the defense will make. And it has changed things because the typical dynamic is the Crown prosecuting the accused, and that simple model usually doesn't shift. Now there's a third-party actor, and not only does someone have independent standing in these proceedings, they also have counsel. It can get quite litigious when it comes down to deciding whether a particular piece of writing or a record is going to be relevant to the extent that it passes the test and can be used in court. Essentially, it slows down the process, usually creates a whole different dynamic. In some cases, turning the complainant at odds, or the complainant would be at odds with the Crown. For lack of a better term, it muddies the waters sometimes, and the accused, so the defense lawyer and the accused are usually fighting a battle on two fronts. There's the Crown, and then the complainant and their lawyer.
What documents or items could a complainant have reasonable expectation of privacy? Can you maybe provide us a little bit of more insight into that?
Well, the case law now is really context specific. So it's less about the format. If I sent you a text message saying, hey, do you want to go to the Blue Jays game on this particular date? And it's an innocuous social event that's very public. The courts likely wouldn't consider that communication to be private, or that you would have a reasonable expectation of privacy in the message. If, for example, there were messages exchanged ever that dealt with drug use, more sensitive information that wouldn't have been disseminated to the public, didn't involve public events, then the court would likely say, well, yes, that there is a reasonable expectation of privacy in that message. Also, the audience has a lot to do with it. If it's a message that was privy to most people, or a large group of people, something posted on social media, then it is unlikely that the court would find there was a expectation of privacy in the communication. It's very context specific, and it's more of an art, not a science. Often they do fall into the private message category, because text messages and emails and that kind of thing that go on between two individuals, usually you're looking at the message and saying, I wouldn't want the rest of the public to see this, and it usually falls into a reasonable expectation of privacy category.
Thank you so much, Phil, for giving us a little bit of insight into the Ghomeshi case and why it's so important in Canadian law and the changes that was brought on by it. And thank you to everyone else for joining us on the Aitken Robertson YouTube channels. Don't forget to like, subscribe, hit that notification bell so you'll never miss another video. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website, or by using the QR codes on your screen now. For legal assistance, call us today, or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.